Dear learners, good day. In this module, we will be discussing the state executive and overview. We have been discussing the subsets of the state government, which comprises of the state legislature, the state executive and the high courts. In this module, we will be specifically focusing on the state executive. I ask or urge the learners to go back and revisit the provision or the module comprising of the union executive, because the state executive provisions and the constitutional mechanisms are quite similar, almost identical, with a few minor changes and exceptions. So when we look at the constitutional provisions pertaining to the state executive, it is Article 153 to 167 of the Indian Constitution, which deals with the state executive. The state executive is placed in the Part 6 of the Indian Constitution. So what is the difference between the state executive and the union executive? The state executive comprises of only 4 entities. The first, at the topmost level, akin to the president, is the governor. The role of the president is replaced by the role of a governor. After that, akin to the prime minister, we have the chief minister at the state executive level. And this chief minister is ably assisted, just like at the union level, by a state council of ministers. And last but not the least, similar to the Attorney General of India, who is a part of the union executive, the Advocate General of the states are a part of the state executive. So we can discern that there is also a dual level of government at the state level as well. So the head of the state is the governor in accordance with Article 153 of the Constitution, but the actual real powers are vested in the hands of the chief minister and the council of ministers. So in this module, we will be discussing briefly the role of the governors of the state, what are the similarities, what are the parallels that we can draw with the President of India, and how fundamentally is the governor different from the president. So there is quite a lot of similarity between the governor and the president. What we see that at the state level, the pattern mimics that of the union executive. So there is a parallel pattern of government at the state level, comprising of state executive and state legislature, comprising of a parliamentary form at the state level, which is comprising of the state legislative assemblies. So one important point of divergence, or where the law digresses, is pertaining to the absence of a position similar to that of the vice president within the state level. The state executive does not have a vice governor or any equivalent position similar to that of the vice president. So that is an important point to be noted as learners. So as we've already discussed, the governor plays the role of a de jure head, that is a nominal, titular or constitutional head within India's constitutional framework. Additionally, the governor is also vested with an additional responsibility as that of the agent of the central government. The governor serves as an agent of the central government, as the eyes and ears of the central government within the state, frequently and constantly reporting all the events and the activities that transpire within the state level, which is part of the federal framework of India's constitution. So though there is a 3-tier structure, there is a strong centralizing tendency within India's federal structure, which we've already discussed. So in order to ensure that the states are not out of bounds and they are not out of tune with the agenda of the union government, and that there is proper implementation of policy measures, schemes and welfare initiatives of the central government, it is the responsibility of the governor to keep the president, who in turn will keep the central government updated and abreast on the developmental activities that are carried out within the state. So it is this role of the governor as an agent of the central government which is of primal importance. So essentially the governor has a dual role, one as the head of the state within the constitutional framework, enjoying the ceremonial position akin to that of the president, and at the same time he acts as an agent of the central government. So when we speak of the concept of a governor, the constitution envisages that each state within the Union of India have a governor of its own. However, after the 7th Constitution Amendment Act of 1956, the constitution was suitably amended to pave the way for the same person to act as a governor of more than one state simultaneously. So joint governorship of there are several cases wherein a same individual or same person simultaneously serves as a governor of two or more states, or a state and a union territory wherein there is the concept of a lieutenant governor and not a governor. When we look at the broad framework, broad provisions pertaining to the governors of the state, it is important to understand what it says and what it entails. Article 153 of the Constitution speaks of governors of the state. Article 154, which is akin to Article 53 of the Constitution, talks about the executive power of the state. Article 154 has to be read along with Article 162 of the Constitution, which says about the extent of executive power of the state. In accordance with Article 154, read with Article 162 of the Constitution, we understand two things. Number one, the entire exercise of executive power of the state vests and is done through the hands of the president, or rather the governor. It is the president at the union level. In here, it is the governor under Article 154. And what is the extent of executive power of the state is specified under Article 162. 155 of the Constitution, on the other hand, talks about appointment of the governor. 156 talks about the term of office of the governor. What is the tenure of the office of a governor? 157 of the Constitution deals with the qualifications to hold the post of a governor of a state. And 158 talks about the conditions of office of the governor. 159 is pertaining to other ancillary matters, including the oath or affirmation of the governor. What is the oath that he takes, which is also quite similar to that of the president, wherein he says that he would ensure the execution of the constitution, right? So it is his duty to uphold the constitution. Within the framework of the constitution, the governor has the duty to do so. And then comes Article 160, which talks about discharge of functions in case of certain contingencies. So what would be, who would be entrusted with the responsibility of the governor if there is some exigency? That is what Article 160 deals with. 161, on the other hand, is a parallel provision which is akin to Article 72, which speaks of the power of the president to pardon. 161 deals with the power of the governor to grant pardons, suspend sentences, remit sentences, and so on and so forth. So essentially, Article 161 is the pardoning power of the governor, and how is it to be exercised, and what are the roles and responsibilities of the governor that is envisaged in terms of the pardoning power under Article 161. And proceeding ahead, we will be taking up the aspect of appointment of the governors of the state. We can clearly see that this is a point of difference between that of the president as opposed to that of the governor. As we've already discussed, a governor is a nominated or an appointed position, and it is not an elected position. Unlike the president, who is indirectly elected through an electoral college in India, the governor is not elected directly or indirectly by the people. On the contrary, he is nominated by the government at the central level, and he is appointed to the post by the president under his hand and seal. So essentially, we can see that the governor is a nominee of the central government. Though he is a nominee of the central government, the Supreme Court has ruled that the governor is not the servant of the central government. On the contrary, the post of a governor is an independent constitutional office which is not under the control or subordinate to the central government. This has been ruled by the Supreme Court. So, when we look at the history of India's constitution framing, there was this debate, there was this idea that governors ought to be elected. In the original draft constitution that was proposed or propounded, we see provisions pertaining to direct election of the governor through universal adult franchise, which was being mooted. But subsequently, due to various reasons and including the possibility of conflict between two heads, one who is elected by the people directly, that is the chief minister, and simultaneously another position of governor, that will create a conflict. This was the point of view, and hence it was decided that it would be better that we adopt a model based upon the Canadian constitutional system, wherein the Governor General of Canada appoints the governor of states, and in India it is the president who appoints the governors of the states, and essentially it is a nominated or an appointed post and not an elected post. So this was the backdrop of the constitutional history concerning the position of the governor of the state. Moving ahead, what are the qualifications of the governors of the state? Under the constitution, there are two specific qualifications that are laid down. Number one, which is non-negotiable, that is, a governor or a person who intends to be the governor of a state is and shall be a citizen of India. Number two, he shall have completed at least 35 years of age. These are the two only constitutional conditions that are imposed upon a person who seeks to become a governor of the state. So a person who is a citizen of India and who has completed 35 years of age is eligible to be appointed as a governor of a state. Apart from this, there have been certain constitutional conventions that have developed over the years in respect of the appointment of governors at the state level. In view of the aspect of a constitutional convention, it is important to bear in mind that these conventions are not entrenched or explicitly specified under the law, and there have been occasions where certain constitutional conventions have not been followed. So what are the constitutional conventions concerning the appointment of a governor to a state? Number one, inevitably and in majority of cases, a person who is appointed as a governor in a particular state is an outsider to a state. It means that he is neither a politician nor a member or a leader from that particular state in question. So what does this serve? What purpose does this serve is the question. The objective is that a person who is a governor of the state, being an outsider, will help us to avoid him being free from local politics. That is, no allegation of bias or favoritism can be easily put upon a person who is an outsider. That is the intent of this aspect of appointing an outsider to the state as the governor. It is to ensure the impartiality and independence of office. That was Constitutional Convention number 1. Constitutional Convention number 2, which says that before appointment of a governor to a state, the central government would consult the chief minister of the state in question. So once again, the objective being that because a governor is expected to work closely with the particular chief minister and the state government, it is important to ensure that their opinion is taken into account before appointing a person, in order to avoid any friction that may emerge between the governor and the chief minister, which will lead to the government or the state machinery coming to a standstill. So as we've already discussed, both of these constitutional conventions have not been uniformly followed, and there have been instances wherein outsiders or rather insiders have been appointed. There have been instances wherein the Chief Minister has not been consulted, but nevertheless, these are important conventions that exist unwritten within the framework of the appointment of governors of the state. So, moving ahead, what are the conditions of office of the governor? Is there any mandate, any other requirement apart from him being 35 years of age and being a citizen of India? Yes, there lies certain conditions of office for the governor position. Number one, he should not be a member of parliament or a member of the state legislative assembly or council. So he cannot be a people's representative if he intends to become the governor. And in spite of being a people's representative, that is an MP or an MLA, if he takes up the position of a governor, the law, the constitution states that from the date on which he takes up such position, automatically he ceases to be an people's representative. He ceases to be an MP or an MLA. Number two, a governor is expected not to hold any office of profit. The conception of office of profit is a thread that lies or that follows throughout the entirety of the constitution, and it is applied for many important constitutional offices, including that of the prime minister, the president, so on and so forth. So the same applies for a governor as well. So a person who holds an office of profit would not be permitted to hold the post of a governor. Number three, he is entitled to usage of the official residence of the governor in that particular state, which we usually refer to as the Raj Bhavan. And apart from this, he is entitled to such salaries, allowances, emoluments, privileges, and protections as may be determined by the parliament. And because of the fact that constitutionally speaking, after 1956, there is a possibility that the same person be appointed as governor in more than one state or in two or more states simultaneously. The constitution also specifies the apportionment of salaries to be paid to particularly such governors who hold office in two or more states between different states, which will be determined by the president. So because he simultaneously holds positions in multiple states as governor, the burden of paying him also ought to be shared between the states. How it is to be shared between the states, the president lays down. And last but not the least, the concept of pay protection is also available to the governors of the state, which is to protect the independence and impartiality of his office, which says that the emoluments, the salaries and the allowances of the governor cannot be diminished to a person's disadvantage during his governorship. So this is the last aspect when we speak of the conditions of the governor. Moving ahead, what are the other protections? How is the oath administered for the governor, and what is the term of office of the governor? So number one, we see that akin to that of the president, the governor is also entitled to certain privileges and immunities. He is enjoying personal immunity from legal liability for his official acts. Because the executive function and machinery of the state is carried out in the name of the governor, you cannot hold him personally liable. So personal immunity from legal liability for official acts is enjoyed by the governor under the constitution. Number two, he is immune from criminal proceedings even in respect of personal acts that may be committed by him during his term of office. So it is to protect the high constitutional nature of the office that during and only during the period of a person's position as a governor, he is immune from criminal prosecution even for personal acts. And during his position as a governor, a person cannot be arrested or imprisoned. This is the second important immunity in respect of criminal proceedings. And in respect of civil proceedings also, there is a check and balance in form of the requirement of a 2 months notice being mandatory before civil proceedings are initiated against him during his term in respect of personal acts. So total prohibition in respect of criminal proceeding during his term of office, partial prohibition in the form of a requirement of a notice of 2-month period for civil proceedings in respect of personal acts. So these are the immunities and privileges that are enjoyed by the governor in accordance with the constitution. When we speak of the oath of office of the governor, we can see that the oath of office of the governor is administered by the Chief Justice of the concerned High Court of the state, or in his absence, the senior most judge of the state High Court. So if it is, say, the governorship of the state of Tamil Nadu, it would be the Chief Justice of the Madras High Court who would be administering the oath of office upon the governor in such cases. Now, coming to the term of office of the governor is appointed usually for a term of 5 years, but even this 5 years is not fixed and assured. So the tenure of 5 years is subject to a broader principle that the governors of the state hold office during the pleasure of the president. So what it entails is that if the central government is not satisfied, they may recall a governor even prematurely under the constitutional framework. Apart from this, wherein the pleasure of the president can be withdrawn prematurely, a governor is also entitled to resign from office by writing to the president under his name. So that being the tenure and terms and conditions of office, we will proceed ahead to discuss the powers of the governor of the states. So it is important to note that on several levels, the powers of the governor runs parallelly on the state level, similar to that of the president. This is particularly so in respect of executive, legislative, financial and judicial matters, wherein their powers are more or less similar to that of the president. However, specifically certain powers which are available to the president are not enjoyed by the governor. They include diplomatic powers, military powers and emergency powers, which are exclusively and solely enjoyed by the president, which does not find any parallel relevance in the context of the powers of the governor. So the governor does not have any military, diplomatic or emergency power such as that which is enjoyed by the president. So when we look at the broad classification of the powers that are enjoyed by the governor, as we have already discussed, it can be bifurcated into 4 heads. Number 1 lies the executive power, number 2 legislative power, number 3 financial power and number 4 judicial powers. So when we speak of the aspect of executive powers, it contains or it comprises of all the powers of the governor in conjunction with the state executive, including his power to make appointments of the chief minister and the council of ministers, expecting information from the chief minister and the council of ministers, and also to ensure the proper functioning of the chief minister and the council of ministers. And apart from that, he is also entrusted with the power to appoint various officers, including the State Public Service Commission, the State Election Commissioner, so on and so forth. So broadly, all the executive powers of the state are vested in the hands of the governor, who exercise it not at his own behest but on the aid and advice of the chief minister and the council of ministers. So this is parallel and runs on similar lines to that of the president and the prime minister and the council of ministers. Number 2 lies the concept of legislative powers. So the governor at the state level enjoys the powers which are akin to that of the president, including the power to summon, prorogue and dissolve the legislative assembly at the state level, and to call for and to address the state legislative assembly periodically, as is done by the president. And the governor's assent or his recommendation may be required in respect to certain bills which would not be otherwise permissible under the constitutional framework as well. Number 3 comes the aspect of financial powers. When we speak of financial powers, the governor of the state also enjoys certain financial powers akin to that of the president. Number 4 lies the concept of judicial powers. When we speak of judicial powers, we are focused primarily upon the power to pardon, essentially Article 161 of the Constitution, wherein the power to pardon people who are convicted or who are held guilty of certain offences are provided for, and what is the extent and what is the level to which the governor of the state can exercise this power of pardoning is specified under the constitution itself, along with its explication as has been done in several relevant and important landmark cases of the Supreme Court, wherein the courts have clarified the extent and powers of the pardoning power of the governor and to what extent it runs in contrast or in comparison to that of the President of India.